We all know parole was denied for the Menendez brothers, but what are the chances they might be able to successfully challenge those decisions? It's the Leonard Files podcast for Tuesday, August 26th, 2025. I'm investigative reporter Eric Leonard from NBC Los Angeles. It is an office edition today because the studio we like to use was busy. We have to share our space. And I thought we would go back and look at the decisions in the Menendez parole hearings from last week, not about the hearings themselves. Plenty of coverage, plenty of other places, including right here. We were on the air till late Thursday and Friday night trying to figure out what had gone on in these hearings that were mostly closed off to the public and our access. We were working off of notes from a pool reporter. But now that it's clear that the brothers don't have a chance at parole through their first parole hearings, we've been hearing lots of stuff about what they might be able to do in order to challenge those decisions. And as it turns out, it sounds like the reality is very, very little. There's no administrative process to appeal within the California Department of Corrections or the Parole Hearing Board. And the legal challenge that could be filed, which has been promised by the Menendez's attorney, is not an easy one. So let's start with what we've heard since the decision was made last week, which I'm going to play for you a little bit of Ted Chen's reporting, Channel 4 reporter Ted Chen's reporting from Monday, when he sort of wrapped up what the possibilities are and what's in the mix.
I still am extremely disappointed and extremely dismayed.
Their lawyer, Mark Garagos, won't give specifics, but he says Lyle and Erik Menendez will challenge the decision to deny them parole, even though there is no appeals process in California's correctional system.
We're going to put this squarely in the governor's lap and in a Superior Court judge's lap.
Among the remaining possibilities to gain their freedom, the Menendez brothers still have an ongoing petition for a new trial or sentence reduction, and they're still hoping Governor Newsom might grant them clemency. But legal experts say none of the options look promising.
I don't expect Governor Newsom to intervene to help the brothers here at all.
Parole, that's gone. Now, the question is, will the new evidence that recently surfaced get a new trial for them?
And you have to remember, the facts of these murders are beyond heinous and gruesome.
Author Robert Rand, who says he communicated with Lyle over the weekend about the parole hearing, says he is confident both will be released if they follow prison rules, which was a factor in the denial.
The Menendez brothers believe they were treated fairly by the parole board. They are getting out. They are going home. They will be set free.
The only realistic shot they have for freedom now is a new trial.
Maybe years down the road, they will have a chance at parole.
Okay, so it's just sort of a roundup of the opinions of those two attorneys that are our legal analysts, Royal Oakes and Manny Medrano, both saying that the idea that they might be able to win parole is kind of over with. So you heard Mark Garagos say that he wanted to put this matter in the lap of a judge. And what he's talking about there is filing a lawsuit, the only kind of lawsuit that can be filed to challenge a parole decision. And it's not one that succeeds very often, statistically, almost never. On top of that, there is a very high threshold for getting into court in the first place. This isn't a case where anybody who files gets to go in front of a judge and make their arguments. This is a little bit different. So I thought we would go for some expert help to try to figure out what the chances are of challenging these decisions or whether or not it's even worth pursuing it.
Yeah, so my name is Bruce Zucker, and I'm a professor in the Department of Criminology and Justice Studies at California State University, Northridge. And I also practice as well, more not as much as I used to. And my area is post-conviction, and in particular, parole matters, life for hearings, parole violations, anything to do with people having issues on supervision or even just getting to that point.
And why is that a legal specialty within a specialty?
Oh, yeah, nobody does it. It's just there's very limited right to counsel. So unless you can afford to pay somebody, and unless you're facing a violation hearing or going in front of the parole board, you normally have to hire your own attorney.
The cases that bring us here are the Erik and Lyle Menendez who were up for these hearings last week. First of all, I got the sense that you have some opinions about the way that the hearings have been conducted in general recently, and I'm very curious about your perspective because for the average person, this is invisible. Nobody knows what goes on other than we sometimes hear about somebody getting a parole date or somebody being denied when they're tied to one of these notable cases.
Right. Well, first of all, and I'm only going by what I'm reading in the LA Times because, as you mentioned, these hearings are closed, except for this anomalous thing that happened with Eric's hearing, and they released the audio the same day, which never happens, ever, ever, ever. 30 days later, they will release the transcript. But hearings, the policy is that each hearing goes 2 hours. The board parole hearings, even in the old days before they had that policy, I never went more than 3 or 4 hours in a hearing, and they do 2 or 3 a day.
These went 10 or 12, right?
Yeah, I mean it's unheard of, and it's because of the notoriety and because of everything else. And and to be fair, anytime you have a high profile case, whether it's revocation or it's a suitability hearing or any other hearings that the board, they don't do revocation anymore, but they used to. But any of these other hearings, when there was something a little more, on the radar of the media and social media, they would slow down and do a lot more work. But this is 6 times as long as most parole hearings typically go and supposed to go.
And is it your sense that the average inmate, absent the presence of a well-paid, large defense team and entourage, does the average person going up for a first hearing get a fair shake?
Now they do. If you asked me the same exact question 10 years ago, I would have said no when I first started practicing.
So
They're
what
a lot
changed?
better. Well, first of all, it used to be that there were less lawyers involved as commissioners. Now, they have commissioners and they have deputy commissioners. Commissioners are appointed by the governor. Deputy commissioners are hired by the board. All the deputy commissioners are lawyers, and lawyers bring knowledge of the law. They bring consistency into the room, making sure these decisions are done fairly according to the law. In the old days, you could have a commissioner and a deputy commissioner who have no legal training, maybe former prison warden, a lot of them are former parole agents or prison guards doing these hearings, and they bring in all kinds of crazy stuff. Now it's a lot different. It's much more, the hearings are much more solid, following the law, following policy. So I'd say most of the time they're actually pretty fair.
So this case again is, or these cases, these two guys are an anomaly because of their ability to present their best possible arguments with the assistance of all these other people that help them. Most inmates don't have all of that, and yet they both got denials, and the denials seemed reasoned, at least based on the notes that we saw. Again, none of us were in the hearing, but on first glance, they also seemed slightly petty in the sense that here you have two people convicted of very violent crimes being denied parole because of mostly their incarcerated behavior, and within that, their rule violations, a lot of them having to do with cell phones. And again, we don't know everything that went on. We don't know all the stuff that the commissioners had available to them, the reports, documents, and things from inside that they were privy to. None of us are. But at first glance, it seems like maybe for the average person, it's more difficult to rationalize a decision like that. What do you make of it, and what are your thoughts about it?
Well, first of all, rules violations, they have serious rules violations, and then they have less serious. There's actually regulations that make that differentiation. I'll tell you this, any rule violation within so many months or even years of a parole hearing is a disqualifier. And I tell my clients that. And with that said, so in other words, I think if it was anybody who had a cell phone violation 6-8 months ago, it would have been almost impossible to get a date. And in their case, they're looking at all their behavior up till this point. with all that said, I think it was actually a pretty good outcome. A 3-year denial, which is the minimum denial they can get. It's 3, 5. I think it's 3, 5.
They said 7 and
11.
15.
Yeah, for 3, 5, 7, 11, and 15. So it's like Charlie Manson always got 15s, right? Because he never did anything, and remotely considered to proper programming or anything like that. These guys got a 3-year denial. Plus, they can apply early and come back 18 months to 3 years. And that's huge because in that time, what the parole board is going to look to is a couple of things. Number one, they got to give them those 18 months or 3 years clean. If they do that, then that pretty much starts, the prior stuff starts going away. Okay, it gets older, it ages anyway, but also they've been violation free between the 2 hearings, which is exactly what they always say. Of course, I wasn't there, didn't hear, but they always say, you must, between now and the next hearing, when they advise them what to do, is you must follow all laws, all rules, no serious or what they call the less serious rules violations. Used to call them 115s and 128s. None of those. You can't have any. And if you have one, you're toast. So as long as they do that, they've also, and we'll know in 30. Well, I know, I heard from the media that Eric's audio was released. I haven't heard it personally, but both of their transcripts will be released within 30 days by law, or at least they're allowed to be, obtained by anybody, including you and me, and the public, anybody. We'll know exactly what they advised them to do, what they admonished them to do, and that's including things like programming or more classes, more self-help, whatever the case may be. And if they do all that stuff in the next 18 months to 3 years, whenever their next hearing is, they're going to get closer to a date, and I'm not worried about that. I'm sure they'll do all that.
Almost immediately, I think it had a lot to do with the release of the audio from Eric's hearing on Thursday, caused, their outside defense lawyer, Mark Garrigus, not the attorney who was handling the parole hearings, to say that the publicity that had resulted from, whether it was a leak or it was intentional, I don't know, had somehow changed the fairness of the proceeding while it was going on. And I think he plans to make some kind of challenge to the decision. So our next question was, well, how likely is that? And in my amateur review of the rules, it looked like the opportunities for an administrative appeal or review within the Board of Parole hearings seems very narrow. And the only recourse is to go to court outside the prison system and sue. And so how does that work, and how often do those work?
It's very unlikely, number one, under the best of circumstances. It's called habeas corpus. We do those in my firm a lot. It's very, very, very hard.
And is then, that, before you go on, is that just because the threshold to get into court with one of those is high to begin with?
Yes. Yeah, they're considered extraordinary writs. I mean, they have to be. And there's also this concept of prejudice. So even if something technically goes wrong in a case, whether it's a parole hearing or, quite frankly, in a trial, unless you can show prejudice to a certain level, in other words, how did it affect the outcome? If you can't make a good faith reasoned argument as to the outcome would have been different, then no. I mean, if somebody, this would never happen, but, well, I shouldn't say never, but because I've seen some things that should never happen. But let's say the board said, you're not getting a lawyer and you must defend yourself because we don't think you're worthy of one. Well, that's different because there's a right to counsel. And even if the hearing was perfect and no prejudice, that's they would have to do a do-over on something like that. But here, I still don't see the connection between releasing the audio from Eric's case to Lyle's case. There's no jury. It's the parole board. It's a different panel, but we don't even know if the second commissioner and deputy commissioner even heard the audio. And even if they did, which they probably didn't, not whether or not they had the opportunity, but frankly, I don't know why they would want to interrupt their day to listen to it. I mean, it's just It's just why. So, but I still don't see how that would prejudice Lyle's case. I mean, maybe there's something we haven't heard yet. So I think it's a red herring.
Okay, but let's put that aside then. If you, inmate or inmate's legal team, disagree with the findings of the people who heard the parole hearing, what are your recourse options?
Habeas corpus. File petition for habeas corpus and make legal argument as to why the decision is erroneous. Now, again, I haven't read the transcript. I haven't, seen anything in the media. There was a pool reporter from the LA Times there, I believe. So I've read his stuff and some other things that are online. And I've seen, as you mentioned, Mark Aragos and others comment about their perception of it. So far, I haven't heard anything that would render this a bad decision. And to be honest with you, I think it's a great decision. I think they did a great job. I mean, it's a 3-year denial on the first shot, which never happens. That's huge. I will say this, and this is something that people aren't really talking about. And this is something that kind of frustrates me as an attorney when I represent people who either believe that want to claim innocence. They say, hey, you know what? It's 25 years later. I'm coming up for parole, but I didn't do that. I wasn't the killer. Or it didn't happen exactly the way they said it did. And so that's what's happening here. You have different narratives as to what happened to Kitty and Jose. The narrative. So what's out there? We know that they were killed. We know that Lyle and Eric shot them. Right? We know they bought the guns a couple days beforehand. The question is why. It's pretty compelling evidence that they were abused. Okay, all of that is a given, I believe. The problem that the parole board has, and this is where I want to read the transcript when it comes out.
Sure.
Is the parole board has this thing called insight, or these terms they throw out. Insight, coming to terms with your commitment offense, accepting responsibility, and being honest about what it is that you did. And then criminal thinking they also throw in there. These are 6 terms that they tell everybody that comes in front of the board. And this is what we prep our clients with. You need to be brutally honest. And you need to, their argument here is that we were fearful, unreasonably so, but we really in our heart believed we were about to be killed, and that's why we killed our mom and dad. And the public narrative out there is like, well, why'd you kill your mom? You were afraid of your dad, okay. But I haven't heard a good statement from either one of them that explains why mom was killed.
It's interesting. Yeah, it's interesting you mentioned that too, because one of the things that was in the ether in the courtroom when they were challenging, or that when they made their resentencing application and they were going through those hearings in Van Nuys, there was discussion about whether the judge might, in fact, following that reason and logical question, might resentence them for the murder of their father, but might not resentence them for the murder of the mother because of that very thing. But then I never heard anybody from the DA's office pursue that. You would think it would come from the DA's office to pursue that argument, and there might have been a passing mention of it, but nobody made an issue out of it. It seems like it would be surprising, or it's surprising to me, that issue would still be one that the parole board would consider when it would look like all that stuff is in the past and settled.
Parole world wants to hear, well, there's something that the psychologists testified to back in the 90s when this started. And it was he said something about how I'm paraphrasing, something about how they were glib, or they were somehow excited or proud of what they did. And that's floating around. And you have to understand something. When you're in a parole hearing, you talked about, well, we don't know what's in front of the parole board. They have their central file, which includes like all kinds of stuff. And we don't know what's in there. It's confidential. We might hear about it referred to when we get the transcript, but we don't know exactly what's out there. If there's a witness that says something happened and the parole board jumps onto it and says, well, you may say that you did A, B, C, and D, but there's a witness out there that we read about in a police report somewhere that says something different, And now we don't believe you. We think that you're lying, even though they're not bound by what happened in court. They're not bound by what happened, in the resentencing hearing. Everything potentially comes in. Hearsay comes in. There's no rules of evidence for the most part. It all comes in. So as a parole, if I was the commissioner or deputy commissioner on the parole board, I can open up the C file and say, hey, wait a minute, this psychologist says that you were pretty happy when you told him that you did this, and that's why you went and bought your car. You just didn't care. That's inconsistent with what you're telling us about being fearful. So I have a problem as a commissioner saying, believing you now that you didn't really have some other motive. And that motive, the government was saying it was fueled by financial gain, that they lost on that enhancement at I believe,
right.
at trial, if I'm not mistaken.
Yes.
But we, the parole board, have to believe that you have insight, you accept responsibility, and that you're telling us the truth. We cannot get into your head, so we can look at all these other factors, and we don't know if you're telling us the truth right now. Maybe you're not telling yourself the truth. And if not, then that goes to the risk of reoffending because you haven't come to terms with your offense. It's what we call what they call criminal thinking. And that's still going on in your head. And so we got to be 100% sure, 99.999% sure that you're not going to mess up when you get out of here. And, this is hanging us up. Now, I don't, like I said, it wasn't in there, but I know that narrative is really crucial. It would be crucial in any case. I've been denied, or my clients have been denied parole because they just are married to their version of an offense because they've been saying it for so long. They don't know anything else. They don't want anyone to think differently of them, and they'll never change. And I've had people go to their grave for that, literally go to their grave with that narrative that's inconsistent with what's that's potentially in the record.
What is it that they would have to do, and then I'll let you go, to advance their next hearing date? They think they said after 18 months they can try to accelerate that next hearing. What circumstances dictate when that does and doesn't happen?
Well, to get an advanced date, you have to show that your circumstance, basically for them would be that they've complied with all of the recommendations of the parole board, whatever those are, one of them being don't get any more trouble, and whatever suggestions they have. But if I were to say something to them, I would say, look, you have a problem with the narrative because and it may be true. That may really be what it is. But the problem is that you're going to get not necessarily the same board. It's random, or it should be random. You may get a different panel. You probably will. And, it's not a jury. These are commissioners and deputy commissioners who hear these cases multiple times a day. And they know the difference between minimization and true accepting responsibility and gaining insight. They know the difference. I've seen it too. I've seen clients get true insight and express it, and it comes through. And I've seen, obviously, many cases of people trying to downplay and come up with alternate narratives because it goes against everything that they've been saying this last so many years. And so until they are able to come to terms with that, if you will, and it's tough because what happens if somebody really, 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 really didn't commit the offense, but the evidence is such and they've been convicted and they're there? Parole board doesn't want to hear you're innocent. So, it's this dilemma. Do you just go along with it because that's going to get you out the door, or do you go to your grave? And I've had both. I've had people change their story, and then I get them out, and I said, look, now tell me, we're outside today. Did you really stab the guy, or did you say that because that's what the board believes, and your first story is true? He says, no, that's what my first story is true. So that's their problem, in my opinion. That's their hang up.
I'm going to leave it there for now, but when we get the transcripts from the Menendez parole hearings, We'll sit down again with the professor and go through all of this and see if there's something new that we can learn from them. Remember, everything we know from those hearings is from notes that were taken by a pool reporter who was the eyes and ears for everybody that was not allowed to attend in person. And in fact, the pool reporter didn't even attend in person. He was remote also. He had to fly up to Sacramento and sit in an office at the State Department of Corrections and watch on a Zoom call, but from their offices. There might be more information in these transcripts that helps somebody with more knowledge of how these proceedings work understand why the parole commissioners reached the decisions that they did. Make sure you click subscribe to our YouTube channel so you don't miss our upcoming episodes. I'll see you next time.